So it's my great pleasure to invite now to the stage Blair Scotland, who's a partner at Dundas Street, who's going to talk about the legal obligations for RSE employers, but from the point of view of what does it look like if it's working well, and how do you reduce the risks in that space. Welcome, Blair.
Slightly alarming to see a photo of myself with a lot more hair than I've got now. It's a bit jarring for the afternoon. Look, kia ora koutou, thank you for welcoming me along this afternoon. I'm going to talk about this particular session through the lens of, I suppose, the most prescient piece of litigation that we've got going on regarding RSE workers, and that's the Soapi and Pick Hawke's Bay case that's been working its way through the courts over the past couple of years. So what I thought I'd do is I'd talk to you. Some of you will have recalled me speaking about this at previous events. I'm going to talk a little bit about the case, give you a bit of a rehash of what happened, and then I'm going to talk to you about the employment court decision and then some of the lessons that arise out of that decision, some of the things that we need that is worthwhile being cognizant of, and talking about the current appeal that's underway and is yet to be resolved. So hopefully we can cover this in fairly short order for you. Now, first things first, the Employment Court decided this matter in 2025. Now, you don't have to just take my word for it. You can actually download the decision for free. I've even put the website that you can click on to get a copy of the determination. But that's the reference number if you want to go and have a look for yourself. I'm going to give you a bit of a potted history of the Employment Court's decision, just so you get a sense of where things sit right now and where some of the lessons have come from. The gist of the case was that 3 RSE workers claimed that their employer, Pick Hawke's Bay, had made unlawful deductions from their pay in contravention of the Wages Protection Act. So they'd made deductions had been made from their pay that they hadn't agreed to. That the employer had failed to fix their maximum number of hours to be worked in their employment agreements, which they said was contrary to the Minimum Wage Act. That as a result, and this is where it gets the crunchy bit, that as a result of deductions that had been made from their pay, some of which they said were agreed and some of which were not, they had not been paid at least the minimum wage in respect of the hours that they had worked, and that was in breach of the Minimum Wage Act 1983. That's one of the sort of key issues arising from this case, as we'll talk about. And lastly, they claimed that the employer had not correctly calculated the value of their accommodation, and therefore the deductions made for accommodation from their pay were incorrect and unlawful. So quite a lot of factually specific information in respect of these particular workers and this particular employer. There was a 4-day hearing undertaken for this, so it was in employment terms, that's a relatively long time for a hearing because often the issues are more confined. This case touched on a number of novel legal issues that had never really been argued before, so it probably took a little bit longer. Now, what was my firm's involvement in this? Well, we were asked by Horticulture New Zealand to appear as an intervener. So we weren't representing any of the parties. We weren't representing the employer, Pick Hawke's Bay. They had their own legal team. We were asked to appear as interveners. And an intervener essentially doesn't get involved in the evidentiary side of things, but it aims to provide a perspective on the legal issues from the client that it represents. So essentially, we were reflecting to the court the broader legal issues from the perspective of Horticulture New Zealand and its constituent members. So we weren't talking about the specific facts that had gone on. They didn't so much concern our version of the case. So This was heard over 4 days. What was the result, I hear you ask? Well, if I work through the various categories, firstly, the court held that a number of the deductions that the employer made from the employee's wages were unlawful. The employer had made a number of deductions, and in accordance with INZ, processes and agreement through the agreement to recruit, the ATR process, had deducted things like half the value of airfares, various other bits and pieces. The employer in this instance had deducted things like the cost of branded clothing, fuel, food costs, wet weather gear, the cost of immunisations, storage boxes. In respect of those particular deductions that had not been approved via the ATR process with Immigration New Zealand, those were held to be unlawful deductions. You may be aware that an employer under the Health and Safety at Work Act 2015 is required to provide at its expense personal protective equipment to workers. In this instance, those deductions for that taken from people's wages for that PPE was also held to be unlawful. The employer had made weekly deductions from pay for a variety of these costs, payments for costs incurred prior to commencing employment. The issue with that is that the consent forms the employees signed didn't specifically authorise those weekly deductions, and they had not been approved in advance through the ATR process by Immigration New Zealand. So there were also deductions that were made for things that just weren't covered there. So, for example, the employer was deducting money for things like missing cutlery. And look, that was, I know there were contested matters in evidence, but again, I suppose one of the lessons that comes out of this flows from when you're making deductions, you have to be very specific. We'll come back to that. The minimum wage, the minimum hours issue, I should say, this was really, I think, an issue that came up at the latter part of the case. It was sort of came out of nowhere, really. Essentially, Section 11B of the Minimum Wage Act says an employment agreement has to state the maximum number of hours that an employee can be required to work. Many employment agreements, and particularly in the sector that we see, talk about, you were given a minimum of 30 hours a week, but it doesn't talk about what the maximum is. I suspect that was just something that a lot of people overlook in their employment agreements, but it is an important thing. It didn't ultimately impact on the outcome for the employer, but is a good salutary lesson for people. Probably the key finding with the next two, one about the minimum wage and the second one about accommodation deductions. As you know, we've got a minimum wage in New Zealand, currently $23.95 per hour worked, or for a 40-hour week, about $958 weekly. Now that is before tax. The Minimum Wage Act protects an employee's pay from having deductions made from it unless certain specific instances apply. Of course, the government is allowed to help itself to workers' pay as long as it's in statute through the form of course, PAYE, pay as you earn, income tax. But also the government likes to help itself to things like ACC levies out of your pay, and if you fall afoul of the court system, court fines, etc., can come out of your pay too. The government always finds a way to get its hands on money when it needs to. But the legislation is otherwise pretty relatively closely guards an employee's pay in this respect. There is an exception in the Minimum Wage Act around the cost of board and lodging, accommodation. So deductions are, in certain circumstances, permissible in that instance. As you can see from the quote taken from the judgment, we conclude that it was a breach of Section 6 of the Minimum Wage Act, which is the part that talks about you can't make deductions to bring anybody's pay below the minimum wage. To make deductions from the plaintiff's pay that reduce their wages below the minimum rate of pay, insofar as deductions were not permitted by Section 7, Section 7 dealing with accommodation payments. So that a pretty sort of a jarring a jarring finding from the court in respect of the RSC and, the whole sort of sector dealing with RSCs. This was, of course, another aligned issue. Again, quite fact-specific in respect of what had gone on with PICs, so not necessarily amenable to every situation, but the principles are quite interesting. The court held, well, look, deductions are allowed from wages and can bring an employee's pay below the minimum wage for accommodation where the cash value of that accommodation is fixed by agreement. Now, the problem is when you're dealing with old legislation, like the Minimum Wage Act 1983, it's nearly as old as, it's nearly as old as I am, that legislation, and therefore it is stuck in its ways and uses language that many of us don't necessarily recognise, which was what creates the legal problems here. What is cash value of accommodation? What does fixed by agreement? The court spent some time looking into these issues. Now, in this particular case, the value of the accommodation had been agreed by Immigration New Zealand through the ATR process. However, the employer did not fix the value of that accommodation and the deductions thereof in the employee's employment agreements. And that was held to be in breach of Section 7 of the Minimum Wage Act. Interestingly, the court went further than that and said, look, even if you had fixed the value of the accommodation in the employment agreements, despite the ATR process and Immigration New Zealand approval, we would have said that that deduction wasn't reasonable. The court went so far, and I think this is interesting, went so far as to say, well, look, the cost that the employer charged for the accommodation took into account the costs that were incurred for that accommodation off-season when there were no employees there. So they even criticised the amount being extracted. The finding of that was ultimately that the employer was only entitled to deduct 5% of wages and accommodations. So the results of that resulted in payments to those former employees of between $6,000 and $19,000 each in terms of wage arrears and repayment of amounts. So, what are the lessons from the employment court decision? Well, there's a variety of them. Taken from this case, deductions, except where you make them lawfully for accommodation, that reduce someone's pay below the minimum wage are likely to be found to be unlawful. The minimum wage is seen by the courts as sacrosanct, and unless you've got a specific sort of legislative out, either you're the government and able to help yourself to people's money, or you meet the requirements around accommodation, any other deductions that bring people's pay lower under the employment court decision would be unlawful. If you are going to have deductions made from someone's employment agreement, and this applies from everybody, you need to be really clear as to how and when you're going to do that, and be specific as to the amounts or the calculation of amounts. Importantly, for accommodation costs, and this goes beyond RSE workers. I mean, we all know, in the primary sector, a lot of people have, as part of their employment, accommodation provided as part of the package. Accommodation costs to be deducted and to particularly bring people's pay below the minimum wage must be quantified as cash value. And what is cash value? Well, the court indicated, well, we think that means market value, but it means market value just for the period that the people are in that accommodation. And they must be, they must be agreed expressly and must be reasonable. Of course, deductions are not allowed for the provision of personal protective equipment for employees. That's a big no-no. You're always going to get into trouble for that one. Hopefully that doesn't come as any particular lesson for anybody. Court went on, you've got to be really careful about deductions for things like missing or damaged property. The cutlery one was the one that the employment court seems to focus on in the judgment. You need to be really clear around that. And of course, one of the things that the court hung its hat on was, well, you didn't even run this past Immigration New Zealand. You didn't even run this through the ATR process, so you don't get to pass go in respect of that one. employment agreements must have maximum number of weekly hours, and if there was a comment made in there, again, not entirely directly in respect to this case, but if you have a requirement for employees to make themselves available to undertake work in addition to the minimum guaranteed hours in their employment agreements, you must have a thing called an availability provision in the employment agreement, and you must pay the employees reasonable compensation in addition to their hourly rate for being available to do that additional work. So that was more of a reminder, I think, in the decision than anything. And last but not least, again, I'm not quite sure why the court chose to comment on this, given it's not strictly an employment matter, but essentially made a comment to the effect that holding on to employees' passports is probably a bad idea. I think what tripped the employer up and drew the ire of the court, well, not ire, I suppose, but drew the attention of the court was that employees didn't, if they had other valuables, they weren't stored for safety. It was just the passports were taken off people, and the employees said that they didn't feel that they had much of a choice. So take that for what it's worth. As I said, you can read that decision online. It's free and available if you wish to dissect it. So, is that the end of the road? No, it's not the end of the road. PIC applied for and was granted leave to appeal aspects of the Employment Court's decision. So, this was focused on two particular questions. As you can see from a number of the lessons, some of the things in the Employment Court's decision were probably never worthwhile trying to challenge on appeal. You're never going to get much sort of luck around those things. But two questions, the court said, yep, we as the Court of Appeal, we want to hear a bit more about this. We want to entertain some arguments around this. So the two questions are as posed up on the screen. Are deductions for costs approved by Immigration New Zealand and otherwise lawful still legal if they reduce wages below the wage below the minimum wage? So quite an important question in all of this. Secondly, in respect of accommodation costs, the questions that they wanted to hear about was, did the approval to recruit process through Immigration New Zealand, was that in effect fixing the cash value of accommodation, therefore making deductions made in accordance with that ATR process for accommodation lawful under the Minimum Wage Act? So the matter, again, Hort NZ asked us, and we appeared again as an intervener, along with the Council of Trade Unions and the Human Rights Commission as other interveners. So again, we three were not parties to the proceedings. We were there to give guidance and input to the Court of Appeal on how the law might work from the differing perspectives of those intervener parties. The matter was heard over 2 days, on the 22nd and 23rd of April. No decision as of yet. We haven't had a particular indication as to when the court may make that decision. From our perspective, we argued on behalf of Hort NZ that essentially some of those deductions, particularly the INZ approved ones, are in essence living costs. Everybody has living costs. Everyone has to spend their pay on living. You know, food does not just drop from the sky. Accommodation does not appear. We sort of talked, gave submissions on those particular issues. The court did seem interested, which seemed happy with that. But of course, they like to play their cards very close to their chest. So if you asked me and said, "Oh, Blair, how do you think it's going to go?" I would say your guess is as good as mine, because it's always difficult to predict. So look, we wait with bated breath as to what's going to happen. So look, hopefully that gives you a picture of a real-life case involving RSE workers and compliance. I think it shows the importance of making sure that your processes, your employment documentation are up to date, meet the current requirements. And the other point I suppose I would make, which is I would be wary of relying, I think there can be a reliance on saying, well, Immigration New Zealand approved this, so it must be right. This case indicates that that's not always true. You need to do your own due diligence. Anyway, that's me. I'll stick around for questions. after this session? Lovely, thank you.
Thanks very much, Blair. So if you weren't clear before this about what the law says about deductions, it's crystal clear now from hearing that particular case. I should have said before the session that we were going to have a third speaker, Dr. Alisi Kotuke, who unfortunately is not available, but it's left us with 10 spare minutes for questions. And a number of you said to me in the lunch break you were keen to ask questions of our previous speakers. I was going to get them all to come on the stage, but that would probably take us another 5 minutes. So at this point, we've got a mic roving around. If anyone has any questions at all for Loa, she talked about the cultural awareness framework, or for Barbara, talking about particular technical assistance, or for Miriama, talking about what they're doing in the Noa Village of Learning, or for Dick from his statistics, and then also from what you've just heard from Blair or Gail. Now is your chance. And apologies for those of you who might have been trying to put questions through the app. We think there's been a little bit of a glitch, but again, this is your chance. So, do we have any questions? You're going to have to yell out because I can't see it. Oh, there's one there at the back.
It's working? Yes.
Working.
Kia ora, and thank you all for your presentations. Very much appreciated. This question's for Blair. I was wondering if you could give any advice or information about a new approach that many employers are trying of setting up auto payments for employees to recover costs for accommodation and other things that would be done by deductions. And could you especially speak to this in the background of Section 12 of the Wages Protection Act, being the one about employers not stipulating where wages are spent? Thank you very much.
Yeah, look, I have seen a couple of employers in the sector sort of say, well, can we set up some sort of other repayment sort of regime, sort of automatic payments? Somebody, I think, muted having an EFTPOS machine available on site, which I thought, oh, that feels a bit extreme, but so be it. So, I mean, look, the short answer is I think that potentially separate to, and there's a question of how separate it is, you could set up arrangements like that whereby people agree to it's a debt owing, they enter into a repayment regime and they pay that directly. The wages go from the employer into the employee's bank account, less lawful deductions, and that the employee then authorises payment for whatever payments are in there. Again, I don't think that's been thoroughly tested. It hasn't been tested as of yet, the lawfulness of those arrangements. I would think that they potentially are. I think the issue, however, that some employers are concerned about is if the employee cancels the authority to make deductions and leaves the country, well, what are the options then for recovering any sort of outstanding debts owed? Limited to none would probably be the view in that regard. So it's, yeah, I think it's potentially available if it's done in the right way. I don't think it necessarily falls foul of the legislation. Again, the argument's much the same as what we ran in the Court of Appeal. Everybody owes, has debts, everybody has living expenses. Rather than just deducting them at source as the wages paid, this is doing it like most of us do, paying your mortgage, paying your rent, paying money at the supermarket. It's akin to that, just doing it in a more organised manner. The issue becomes, however, the enforcement if there is default. Does that assist? Thank you.
Thank you. Do we have any other questions? No, it's all crystal clear? Oh, I've got one at the back there. Gail.
I think I'm going to disappoint because while we were an intervener in that case as well, as Blair pointed out, It's our team of lawyers who are the ones who are the experts in giving that legal perspective from a human rights perspective rather than myself. As an economist, I don't have that particular expertise, sorry. But yeah, if you give me your details, I'll happily respond back.
Thank you. Okay, I think we've got time for one more. Lucky Lars. This side of the room's doing really well. I've got one at the back there. I hear you waving, but I can't. Sorry. All right. Look, I want you to give both Blair and Gail a big hand for their presentations. Thank you.